Okay. Hello, my name is Hannah Steffen, and I am the lead online editor for the Journal of Law and Inequality's 40th volume. Today, we are very excited to welcome Professor John Lee for a conversation about professional sanctions. So, Professor Lee, thank you so much for joining me. Could you just start us off by introducing yourself and providing some brief background on your research on sanctions?
Yes, well, I'm so excited to be here and to be asked to talk about my work. I am Professor John Lee. I teach at UMN Law School. I've been a professor here for 4 years. My primary area of scholarship is in PR, legal ethics, but in particular, I'm interested in how state authorities are regulating and sanctioning attorneys who commit ethical violations that go beyond our traditional lawyer-client service obligations. So not things like competence and diligence and trust accounts, but more attorneys who are engaging in things that go more broadly to the legal profession, things like fraud, abuse of authority or breach of trust, and especially harassment and discrimination.
Great, thank you. That's helpful background. So I know part of your research has involved fitness to practice provisions. So I'm interested if you could describe those provisions a little more thoroughly, maybe the history and various current approaches that states take to applying them.
Yes, so new attorneys, when they are going in front of the bar to be licensed, they actually have to show, give evidence that they are fit to practice law. So law students have to complete this very long application about all of the places that they've worked, sort of criminal conduct, credit history, and all of those things are intended to ensure that the public is interacting with an attorney who we as the profession or the state bar believes is fit to practice law. And so historically, our sanctioning of attorneys was, I would say, relatively haphazard. It didn't happen a lot. It wasn't very professionalized. And then in the middle of the 20th century, we started to create codes that had a variety of provisions, most of which were about those traditional lawyer-client obligations. But then there were a set of obligations that were about the integrity of the profession, right? About sort of, having attorneys that represent what we want in the profession, but also don't put the public more generally at risk, right? Not only in lawyer-client relationships, but beyond that. And so they were all in one rule. It's called 8.4. And the most general of these provisions, which we call catch-all provisions, was the fitness to practice provision. And so it tracked a lot of the language for bar admission and said, if a lawyer commits misconduct that indicates or reflects adversely on their fitness to practice law, that was sanctionable. And so it was being used at that time to sanction conduct that our code hadn't quite caught up to. So particularly around lawyers who use their position of authority to engage with sex with clients, right? Often in a more coercive manner, but a variety of things, right? There was just no rule that quite covered it. And so as we transitioned in the early 80s, or the ABA did, and states tend to follow what the ABA did in the early 80s, they got rid of this provision, in part because they were concerned that it was sort of vague or overbroad, that it might be leveraged by a disciplinary authority to sanction conduct that shouldn't be sanctioned, right? Or in particular, the flip side, to sanction attorneys who are minority attorneys or who have unpopular views, right? They were also concerned that we have so many rules, do we need another rule? And so most states followed suit. 7 states, though, have actually kept this provision and have been continuing to use it in the scholarship that I have done. So I do a lot of empirical work. I actually look and see what states do. That several of these states are using it to sanction attorneys who commit violations like harassment and discrimination against not only clients, but also others in their law firms or the public more broadly. It's also being used for breach of trust or breach of authority. So the idea there is for public officials in particular, that they have a lot of trust placed in them. We are seeing this in the news sort of playing out. And the idea that when a public official who may be elected, maybe not, sort of abuses that position of authority, that indicates that they are unfit to practice law. So part of this for me, and again, not every state has this provision. Part of this for me is I feel like there's somewhat of an expressive component, like the profession is saying something when they sanction an attorney and say, this conduct we believe indicates or reflects on this attorney's fitness to practice law. That, from our public protection standpoint, that might be saying something, right? And as we know, the transparency of the profession is constantly under attack. And so in part, this provision I see could play that type of role.
Yeah, definitely. That's really interesting. Thank you. And I think there's, a pretty clear line there too between sort of the expressive things that you talked about and the application of this rule in general, that can, the application of these rules can impact members of historically marginalized communities, sort of one way or the other, whether, they are being protected or not. Can you talk a little bit more about that relationship?
Absolutely. And so you have highlighted the central tension that we have when we are adopting rules, particularly rules in which it may be based on conduct such as speech, insults, right? Engaging in abusive conduct. That on the one hand, we know that as a profession, we have under-regulated attorneys who are engaging in harassment and discrimination, right? And in fact, there is a specific rule that the ABA has adopted. A lot of states have not. It's called Rule 8.4G. It is a specific anti-bias provision where a lawyer is engaging in harassment on the basis of race, sex, ethnicity, a variety of protected classifications. Interestingly, it's come under attack on First Amendment grounds, right? Concerns that we will actually use it in ways that are itself biased, right? So there's this tension that when you have a provision that may be applied in instances that, it's not a traditional lawyer-client obligation, it's more about abusive conduct, for example, that can involve speech that on the one hand, we know that that's being under-regulated, right? In fact, when Model Rule 8.4G was adopted by the ABA, about 70 law professors, prominent attorneys came up one by one and told their individual personal stories about how that had affected them, often in the law firm environment, right? That they had experienced, harassment in the workplace. And so we know that is under sanction, right? And that's why that rule was adopted. But at the same time, all of these rules, including a very general fitness to practice rule, when put into certain hands, right, particularly if state bars are relatively not transparent with the way that they investigate and sanction attorneys, that we are concerned that it will be used more often for attorneys who are marginalized, right? Whether that be on account of race, ethnicity, gender, or viewpoint, right? And so all of those things, all of that tension kind of comes to bear here. So in part, we are trying to think about sort of if there are potential risks or potential errors, which way do we allow those to occur, right? Is it that we have a rule that is more narrow, that may not target some of the misconduct that we hear is happening? And I think that many attorneys in practice know is happening. On the other hand, do we have a more general rule that can capture that misconduct, but that because of its broadness could be ripe for potential abuse, right? And often I don't believe that that would be happening intentionally or consciously, but we know that unconscious bias exists, right? That's what the research tells us. And so given the relatively non-transparent grievance process, might certain attorneys be more likely to be sanctioned under a broader rule? And who are those attorneys?
Right, that's really interesting. And it's so interesting too, you talked a little bit about the history of Rule 8.4G and its passage, and it seems like it was really popular at the time it was passed, but now there's more controversy because of the reasons you outlined. So, I mean, is it a problem with the rule itself or the way that it's applied?
This is a fascinating and complex question. So I've written a bit on this in my scholarship. So Catching Unfitness is my article. There I talk about, as you said, the ABA at the time. So it took about 30 years, quite frankly. So it wasn't quick. The ABA takes a while to adopt a new rule and realize, initially it was being brought up in the early 80s, and our understanding of harassment and discrimination is much different, I believe, now than then. But the most recent push happened beginning in about 2011. And so it still took about 5 years. But as you said, sort of progressively as draft became second draft, third draft, right? That it actually became broader. And in fact, broader than any other anti-bias provision that individual states had adopted. About 20 states have some version of an anti-bias provision, but prior to the passage of 8.4G, they were narrower often, both in terms of the classifications involved, but also because they involved intentional misconduct. So 8.4G is broader in a variety of ways. First, it is not only intentional misconduct, but unreasonable misconduct that is harassment and discrimination, right? And so that state of mind issue is something that when states went to state adoption, there were some that were concerned, right? That we would be sanctioning conduct that was not intentional. Another issue regarding the rule and its construction, particularly in the comments, was that it deals with conduct related to the practice of law, right? And for law students or law professors or lawyers, when they hear the word related to, that can be viewed narrowly or very broadly, right? And so what is conduct related to the practice of law? Well, that certainly is legal practice, but it probably are things beyond legal practice. So like a CLE event, right? It may be a law firm holiday gathering, right? Or just other sort of social events that lawyers may be involved in. And I think as we expand the possible places where that rule could apply, there were some that were concerned that it would cover times when a lawyer didn't have their lawyer hat on, basically, right? And so more what we would consider personal conduct. The other issue is, particularly in the comments, is the types of events and things that they said that lawyers could engage in. So they said, for example, lawyers can engage in a diversity effort, right? So to promote greater diversity in the profession. They also eliminated a provision that said conduct covered by the First Amendment is not regulated here. Now, of course, any conduct that is protected by the First Amendment, we can't sanction, right? But there is a message that some took from that, right? The fact that the explicit protection in the comments about the First Amendment was removed suggested to some that certain viewpoints might be valued over others. The fact that certain types of conduct were explicitly identified as not violating the rules led to concerns from those, for example, who have said, well, what if I argue or posit, I shouldn't say argue, at a CLE event that the Fourth Amendment does not cover trans individuals, right? Sort of legal doctrine argument, right? That someone might say that that is, conduct that is harassment or discrimination, right? On the basis of gender identity, right? And so again, it's not clear that 8.4G covers that, right? But it was sort of how the comments were constructed led some states to believe that it might be wielded in fashions that were sort of targeting unpopular viewpoints. So a lot of First Amendment concerns. In fact, a judge in Philadelphia granted a preliminary injunction saying that that it could not go into effect or to prohibit it from doing so because it may violate the First Amendment. Now, that was a preliminary injunction. It was a trial court in a state, a federal court, right? But not at a precedential level. But I think a lot of that sort of led states as they were considering adoption of 8.4G either to not adopt it or to adopt a more limited version of it.
That's really interesting. Thank you. And I also, I see your point about the pros and cons of having a broad provision and how that sort of plays out in practice in ways that can protect or harm certain communities. I'm curious, too, about the distinctions between 8.4G and then the more general fitness to practice provisions. Have states, you mentioned there are 7 states who have those more general provisions. What have the outcomes looked like in terms of protecting people using those, and would we benefit from a wider application of those provisions?
Great. Yes. So I will first talk about anti-bias provisions, which are, it's interesting. They fall within the catch-all rules often, but they are more specific, right? Because they are specifically about bias and prejudice in the profession. At the time that Model Rule 8.4G was adopted, there were some within the ABA that said that the concerns of those, that it would be wielded in an overbroad fashion or wielded in a frequent manner, were overblown because states weren't using their anti-bias provisions. Now, that's a really interesting argument, right? Because on the one hand, great that we don't have as many concerns that lawyers will be sanctioned for this provision, but is that really just under enforcement, right? So the central concern, and it's quite frankly why it's so difficult to know about the impact of a particular rule, is that we don't know what the baseline is, right? When is harassment occurring? But either A, there's no grievance filed, right? Because for example, in many states, a person who files a complaint with the bar, if they are another attorney, right, you actually in most states have a mandatory obligation to tell the bar if you know of conduct that is a violation of the rules and raises a substantial question of their fitness to practice. There's that language again, right? But there aren't any protections for lawyers in many states who make a report, which means their employment could be at risk, or the reputational harm potentially, right, is being known as someone who made a complaint. So because of that, we don't know what the baseline numbers are, right, in states generally, right? What I can tell you is what I see in states that have adopted a fitness to practice provision and how it is being used there. And again, I can't tell about grievances that were filed and didn't lead to any sanctions, right? I can only talk about what I'm seeing with regard to sanctioning. And I will give you two examples. So one is in Colorado. So Colorado is a state that has a fitness to practice provision. And their provision is used only as a gap filler, meaning if there's a specific rule on the books that covers the misconduct in question, they cannot find a violation of their fitness to practice provision. So that's actually really helpful if you think about it, like, because it really has to be sort of novel for that jurisdiction. They used it on multiple occasions to sanction sexual harassment prior to their 2019 adoption of a specific anti-bias provision that covered that conduct. So we know in a state like that didn't have an anti-bias provision, that this actually allowed them to sanction an attorney that otherwise would not have gone sanctioned. Another example is in Ohio. So Ohio actually does have a fitness to practice provision and an anti-bias provision, a specific provision that is written in such a way, it says, a lawyer who engages in unlawful harassment or will be sanctioned. And part of the concern, I think, with those grievances that have been filed is, what does unlawful mean? Does unlawful mean unlawful under federal law with sort of all of the sort of, litigation, the defenses, how pervasive is the misconduct? Is it a hostile work environment? Like, what do I have to prove, right? Just to get a sanction of this attorney, do I have to prove a case within a case, right? Just to do that. So in Ohio, they have used and cited the fitness to practice provision in lieu of their specific anti-bias provision. And of course, we can't know exactly why they are citing one and not the other, right? But my hypothesis is that at the very least, there might have been concern, right? That given some of the limitations in the way that their anti-bias provision was written, that they might have an argument that it was not unlawful under federal law, for example. And yet, I think from most attorneys' standpoint, and I've read all of these cases, right? So I have the wonderful or terrible job, I should say, of reading thousands of bar sanctions. And the conduct in many of these cases is truly egregious, right? For example, in Ohio, it was a law firm partner who had a summer associate, so a 2L summer associate, and had the phone number of that associate, started texting with that associate, and suggested at least that her position in the firm might be more secure if she engaged in an intimate relationship with him, right? And as you can imagine, the power dynamics there alone, that employment is somehow tied to engaging in sex with a partner, is pretty clearly the type of conduct that we want to ensure does not happen in our profession, that lawyer was sanctioned under the fitness to practice provision. So those are the types of things that I'm seeing. And so I can't, I would love to be able to quantify exactly, what is the impact? And I have in my article some sort of proxies, some ways to get at that. But, at the end of the day, what I think about is I read the individual cases, right, where I see the misconduct that is leading to a violation of the fitness to practice provision. And, unless and until I start to see a number of cases that involve a violation that raise concerns for me, when I start to think about that balance between something going unsanctioned and the times where it could be used in an overbroad fashion. And once I see those, I think I'll have a better sense of where I am. But until I do, and realize those would be subject to an as-applied constitutional challenge, right? Or some challenge, right? That this was being used in an overbroad manner or in a biased manner, knowing that we are sanctioning attorneys and knowing that attorneys, at the very least, would be able to recognize those constitutional arguments when they occur. They may have to incur a cost in fighting that sanction. I don't deny that. But as between not sanctioning that attorney that I'm reading that opinion for, and this not yet realized from my standpoint risk, I'm on the former and not the latter right now.
Yeah, that definitely makes sense. And thank you. I think, that example too that you shared is so horrible and really highlights, a lot of the
Absolutely.
behavior that these, rules are seeking to prevent and mitigate. And it just makes me think, you said you only know about the cases that were reported and were sanctioned. And it just makes me think about everything that isn't reported and isn't sanctioned. And even further too, I know there are some cases where states are permitted to keep sanctions private. So I'm wondering about, the balance of that and what we don't hear about and what sort of the effect of those private sanctions has in this area.
Yes, and so that is my next area of research as I start to think about, what we can do as a profession to increase public confidence, but also protect the public from risk of harm. Immediately, what came to mind for me was the ability of an authority to issue private sanctions. So I think most members of the public, and quite frankly, I think most lawyers think that most sanctions or all sanctions are public, right? Like, I'm sanctioned, the world is going to know about it. Certainly there's a reputational injury that one may suffer. We believe that's probably justified, right, for public sanctions. And so historically, all sanctions were public. Beginning in about the late 1920s, state bar associations, which are who in the sort of early 20th century, they started to take on a more prominent role in the investigation of grievances. And so they started to issue private sanctions. There are competing theories about why we have private sanctions. So on the one hand, I think the paradigm that people use for those in favor of them are the inexperienced attorney, right, who just got barred and they miss a deadline in a case, right? And to think about sanctioning that attorney publicly, I think especially in this day and age, right, with the internet being a thing, right? Historically, sanctions, even if they were public, were in the newspaper, like who was reading those, or trade journals. But now with the advent of the internet, provided that they are published, that maybe we feel like that's just too harsh, right? And so, what do you do instead? Well, maybe not sanctioning it isn't what you want to do. So having a private sanction, sort of that best case scenario, right? And so if you think about it though, that is a place, because of the lack of transparency, and most states that issue private sanctions don't tell us anything about the sanctions that are private, right? That's, I guess, what they would say is part of why they're private, right? Is that what is going on underneath, right? Are places where, a lawyer who is committing, for example, harassment and discrimination, gender violence, things of that nature, because of our historical view of those as being sort of less egregious among some people, right? Sweep it under the rug, we'll privately sanction them, they won't do it again. So that was part of my concern. So what conduct, right? It's private. What conduct, right? Well, the ABA actually says that private sanctions should be made public, but de-identified, right? So don't tell us who the attorney is, but tell us what the conduct is. And so if you think about it from a transparency perspective, that might be a good in between, right? Well, of the 37 states that issue private sanctions, and most states do, 5 actually issue sort of extensive information about individual sanctions to allow you to really, at a granular level of detail, see that. So that alone is concerning. And we do know, and I'm doing research on this right now, we do know that there are instances, especially when they become public, a lot of times a jurisdiction will say, a state will say, this attorney was privately sanctioned in the past 1 or 2 or 3 times or 4 times, right? And so then it's like, wait a minute, why are all these private, right? And so, the other thing is that the majority of sanctions in those 37 states are actually private, not public. So that means that more than half of the sanctionable offenses where they actually issued sanctions, the public is completely unaware of it, right? And we, among those of us in the profession who are like PR scholars or thinking about changes in the rules, we don't know either in many of these states what that conduct is. And that gap to me is, in an era of transparency reckoning, right? I mean, we are seeing it, from, the highest levels of government, police departments, gymnastics, right? Just areas where the lack of transparency, the sort of closed door nature, corporations, TV stations who have had very prominent instances in the, wake of the Me Too movement. We are seeing instances where some are not sharing information, and there has been a sort of push for more transparency. And the legal profession is actually one of the last places where we have seen this groundswell or heard a groundswell of people saying, wait, more transparency, right? But I think it's just a matter of time, right? And I think as more of these cases start to come to light, then I think that we will see questions. Well, why is this private? Why have we waited so long to really peer behind the curtains of what's happening in these states?
Yeah, that's fascinating. And it just really does seem like such an area that's ripe for abuse with these private sanctions. But as you said, it's so hard to know since they are private. So it'll be really interesting to see, what sort of this movement reveals.
Yes, and so I'm super excited. That's my next article. Is I really wanna have a nuanced look, right? Because on the one hand, private sanctions could be used in really beneficial ways, right? For those inexperienced attorneys, the one-off thing, otherwise unblemished record. If that's what it's for, I think that's one thing. But if it's not, then we have a whole other issue on our hands.
Definitely. Yeah, definitely. Well, thank you for that. And I'd like to thank you so much for your time today, Professor Lee. This has been so interesting and informative. I know too, so I'll leave you with the final thoughts and final words. And I know too, after learning about important topics like this, people are often curious about how they can stay engaged and involved. So besides reading your forthcoming research, do you have any other recommendations or any other final thoughts to share?
Yes, so I would say certainly for newly licensed lawyers or law students as one population, getting involved in your bar association, but also a lot of times there are committees that are looking at revisions to our model rules, right? And actually, I find that law students who have just taken the MPRE are a really great sort of set of people who know what the rules are and who have experience, perhaps as a summer associate or a newly licensed lawyer, a lot of these things. I think for members of the public, it is really about sort of seeing in your state what information is being shared, seeing what the rules are. Almost invariably, this is an administrative process state by state. So, the ABA has its own sort of model rules, but then each state has to work on adoption, which could be beyond what the model rules are or less than. They ask for notice and comment. So that would be a time where you could get information on that. And just keeping aware of what's going on in the news, and sort of seeing attorneys who are being sanctioned or not being sanctioned. I think that is another area where just bringing that to light, sort of seeing what states are doing on these types of issues is quite important.
Great. Thank you. And thank you again. I really appreciate you speaking with me today.
Thank
Thanks for the great
you.
conversation. Yeah. All
I
right.
appreciate
Bye.
it. Thanks so much.
Thanks.